weekend. It will also be available via our website at www.DunlapSLK.com. There is a link in the chat section that a person from our firm will be posting the PowerPoint slides for you to download that we'll be viewing today. And my screen will be shared and you can follow along there. So hopefully you can all see my screen. If you cannot, please indicate so in the chat right now. I'll be stopping for questions periodically during this webinar, and to ask a question, simply use the chat to do so. I'll take this opportunity to introduce Tracy Kelso, who is our Director of Tax Services at the firm. And at our time for questions, Tracy will be reading them aloud for all of us to hear, and then I will be answering them the best that I can. If your questions pertain to something that we will be covering later in the webinar, she will just be indicating that to you via the chat. We expect the webinar to run approximately an hour, depending on volume of questions, but be assured that Tracy and I will be staying on the call until we have answered all of your questions. With that being said, welcome everyone. I wish I could see all of your smiling faces in person, but unfortunately that is not possible due to the coronavirus outbreak, and hence our need for this very webinar. My name is Drew Prisky, and I'm the Director of Payroll Services here at DunlapSLK. On behalf of the entire firm, I want to thank you for bearing with us as we adjust to working remotely, as I'm sure you are as well. It has certainly presented new obstacles in my life, working from home with two young daughters who view these days off from school as a free vacation right now. And they're upstairs with my wife, and hopefully we won't hear them. So we all know we are now in not only extremely difficult, but unprecedented times, and not just right here in our communities, but globally throughout the world. As business owners, you have an unbelievable task in the weeks and months ahead navigating through this storm while doing everything you can in your power to keep your companies afloat. And one of the biggest challenges you are no doubt already facing is what to do with your workforce in light of Governor Wolf's stay-at-home mandate and that all non-life sustaining businesses close their doors, as well as the federal government's recent bill, the Families First Coronavirus Response Act. The goal of this webinar today is to provide an overview of the mandates and bills passed and what it means for your businesses as we all work to make it through these tough times. It is important to remember that this is an extremely fluid situation, and these mandates and bills that have been passed or are set to be put in place do not provide guidance on every aspect listed in them, and they are subject to change as further adjustments, clarifications, or amendments come forth. Our agenda today will be as follows. We're going to start with just a brief overview of Governor Wolf's mandates for PA businesses. And then we're going to move into the Families First Act and how it affects you. And at the end, we'll touch on some PA unemployment tax rate relief. And then we'll, although I'll be stopping for questions throughout the seminar here, we will have a final question and answer time for anything that we have not answered. So with that, let's dive right in. So Governor Wolf's mandates started last week. It started with his request that all non-essential businesses close. And non-essential businesses at that time were all your entertainment businesses, restaurants offering dining services, movie theaters, things of that nature. And at the time, it was a voluntary request to reply. Not enough people complied with that, so he moved into his mandate that what he called all non-life sustaining businesses must close their doors. He issued a list of what those businesses are. It's been since tweaked. We do have a current version of it coming up on our website. If it's not there yet, it will be there today. So if you're still unsure on what category you fall into, you can double check there. This past Monday, he issued then a stay-at-home order for surrounding Philadelphia counties, including Bucks and Montgomery. And it's important to note, though, that the stay-at-home order is in addition to his mandate. It's not replacing his mandate. And the life-sustaining businesses, the life-sustaining businesses can remain open at this time. So if you are already a life-sustaining business on that list, the stay-at-home order doesn't directly affect you. It is recommended that you provide employees with an email or letter stating that they're able to commute to and from work at a life-sustaining business. The enforcement is beginning, you'll see. So I don't know yet if they're going to literally be stopping people on the road, but enforcement's beginning. It can be done by local authorities as well as other government jurisdictions. It can result in fines, losses of license, loss of tax credits, and even imprisonment. And hopefully none of it comes to that. But that is what they're saying about the enforcement at this time. The Department of Community and Economic Development has also issued guidance from Pennsylvania. And basically what it means, what they've issued, is that if your business is not life-sustaining, but you have jobs for life-sustaining entities, those jobs may stay open. So if you're a contractor, electrician, or just in general, you have a security entity, something like that, where you have jobs that are running and operating at a life-sustaining businesses, those jobs can stay open and you can cease work on all other jobs. So if you haven't laid off your entire workforce yet, you can have some employees working at those jobs. So that's a quick, brief overview of Governor Wolf's mandates. I'm just going to pause for a few seconds here, and if you have any questions that I can answer about that, let me know. Otherwise, we'll move on in about a minute.
Drew, we have a question. Are work from home jobs that are not life-sustaining mandated to close?
No, if you can work or telework from home, you can continue to do so. So a number of businesses have gone from that, gone to that of working remotely. So if you can work remotely, you are not subject to have to close your doors.
Drew, we have a question about construction. We are building a bank branch. Are you sure we can continue to complete the work? We are 1 week away from completion.
That is my understanding. I specifically had a call earlier this week with the DCED, and they did indicate that you could continue to work on jobs, and banks are life-sustaining businesses. So if you need any additional information on that, let me know. We can also give you the direct phone number to the Department of Community and Economic Development to confirm that as well. But I have not heard that that has changed. So I believe you could continue to work on that job.
This is a good question. It actually affects us as well. Can staff go to an office to pick up materials to work from home?
That is a great question. I'll tell you the position we're taking on that. It's that our business is closed to customers and clients. So they obviously cannot be there working. They can't come in because it's too difficult to work from home or anything like that. If you do need to run down to the office to pick up a couple things, they're recommending that you just keep the normal practices if multiple people happen to be there at once, of staying 6 feet away from people. But we are understanding that you can go to your office to pick up things to continue your work from home, but you can't physically be working there. I should mention too quickly that hopefully that offers some clarity on a lot of businesses I've heard we're trying to go to skeleton crews. Skeleton crews are not permitted if your business is forced to close. You need to be working from home or shutting the doors.
Okay, we have another question. We are working on a memory care facility from the ground up. The job was shut down. The owners are working on getting a waiver. If my guys don't want to go, I can't make them. Also, there are no inspectors out there.
Our position and interpretation is that you can't force people to go, and we'll get into the sick leave and FMLA leave part of this bill, but you can't do anything to discourage your employees from the virus. So I'm not aware of any provisions where you can literally make them go. The fact that there's no inspectors there, not sure that matters. If they get the waiver, if they do get the waiver, then they could continue to operate. And if you have employees that want to go, they could continue to go.
And then if you work in an office alone, are you allowed to go there and work?
I don't believe you are. I believe if your business and if you're in the business of a non-life sustaining business and you happen to work alone, I don't believe under Governor Wolf's mandates that you should be going to the office. Okay, in the interest of moving on, I'm going to continue on here, but please don't stop asking questions. We will get to them at the next break, and we will try to clean up anything that we missed at the end. So the Families First Coronavirus Response Act. The key components to this bill: the bill mandates free testing for coronavirus. It strengthens food assistance programs. It provides safeguards for Medicaid benefits. It enhances unemployment benefits and aid. It expands FMLA, and it establishes paid sick leave. We're going to focus on the last two. We're going to focus on the expanded FMLA, expanded paid leave, sick leave. We will touch on unemployment benefits, but not so much as it pertains to this bill. That's more just advice and FAQs that PA Unemployment has posted. The first three provisions of the bill, we're not going to touch on at all in this webinar. All right, so who is affected by the Act? For U.S. employers, the Act is in place for U.S. employers with less than 500 employees. So to be clear, if you have over 500 employees, you are exempt from this Act. You do not need to pay out the leave, but you're also not going to receive credit should you choose to pay out the leave. So just want to be clear with that. It's for 500 employees or less. And there's two parts to it for the paid leave. The first provides up to 12 weeks of leave under FMLA for eligible employees who have been employed for at least 30 days and are unable to work or telework due to a need to care for a son or daughter under 18 years of age when their school or place of business has closed, or the child care provider of such son or daughter is unavailable due to COVID-19. At least 30 days and unable to work or telework are key components to this, okay? If an employee has not been with you 30 days, they're not eligible for this. There wasn't enough guidance at the time issued on, but I would believe that if they crossed the 30-day threshold of employment, they would then become eligible. That was not specifically spelled out in the bill. The other key, unable to work or telework. If you have employees who've been working from home and you've been paying them, even if they have a child at home, it's going to be tough for them to say they can't all of a sudden work from home. So it doesn't mean there aren't extenuating circumstances that could change that, but just be aware that, again, if you can pay them from working from home and they're going to continue to work, you don't need to offer the leave, but again, you don't qualify for the credit. So then moving on, there's the second part of the bill, which creates a federal paid sick leave law providing for employer paid leave of up to 80 hours to employees for COVID-19 issues. And we're going to get into exactly what those issues are in a little bit. But two parts to the bill, paid sick leave and then FMLA. For purposes of determining the 500 employees, it's important, it is the employee count at the time of enactment. And it's regardless of full-time or part-time status. So if you remember previous other bills where they talked about full-time and part-time equivalencies, you don't have to do any of that calculation here. It's just straight off the number of paychecks you're paying. Employees hired after the enactment date still qualify, since you'll hear that this is going to run until the end of 2020. There's no guidance at this time on what happens if you pass 500 employees during this time. The bill does not clarify, could you stop paying the leave, nor does it clarify if you should continue to pay the leave. So we don't have guidance at this time on that. The bill is going to take effect on April 2nd, 2020. It was passed March 18th, but it does not take effect until April 2nd, 2020. So to be clear, if you have people starting, hopefully not starting with the virus, but if they are, or they have child care issues during this week, the bill is not enacted yet for you to get the payroll credits we're going to discuss. So it's not in place till April 2nd, 2020, and it will run till the end of 2020. And we're expecting that more guidance on things that there hasn't been guidance on. We're expecting that more guidance will become available over the course of the next week here as we approach April 2nd. We're going to start with the expanded FMLA portion of the bill. The Act requires employers to temporarily expand FMLA protections and benefits to employees who have been employed 30 calendar days and need leave as a result of a school closure or closure of child care providers related to COVID-19. The new expanded FMLA leave includes both unpaid and paid employer leave. The first 10 days of FMLA are unpaid, but an employee can elect to use accrued vacation, personal, or sick leave. I'd like you to put a pin in that note there, because we're going to come back to that when we talk about the paid sick leave portion of the bill. After the 10 days of unpaid leave, the employer must pay employees at 2/3 of the employee's regular rate of pay. This paid leave is limited to $200 per day and $10,000 in aggregate. Okay, so it's $200 times 5 days, $1,000. $1,000 times 10 weeks is your $10,000, and that's per employee. Okay, it's not per company. So if you have multiple employees taking advantage of this, you're going to be $10,000 in aggregate per employee. There are some job restoration provisions of FMLA that generally apply with respect to the new COVID-19 related leave. There is relief afforded to employers with fewer than 25 employees, and it specifically states that such employers need not restore an affected employee to his or her position if the position ceases to exist. However, an employer could be subject to other requirements, including reinstatement to an equivalent position if one becomes available within a year period. So a little bit unclear there, in my opinion. But basically I'd interpret that to mean that if you're under 25 employees and you have to, somebody's on FMLA, you don't have to bring them back to the same position unless an equivalent one becomes available within a year. It's important to note that all aspects and rules of FMLA still apply. This is an expansion, not a replacement of the Act. And keep in mind, or just bear with us here, we're not going to be going into all the rules of the original FMLA bill. So if you have specific questions about that, I'm going to ask that you reach out to your accountant or contact at the firm on any questions there. But just note that if something's unclear here, it's going to defer back to the original FMLA bill. So FMLA was the one part of the bill. Paid sick leave is the other part. Paid sick leave. Employers must also provide paid sick leave in connection with COVID-19. The Act's paid sick leave provisions apply to all employees, even those employed less than 30 days. So if you have anybody who falls under this provision, under these provisions here, it doesn't matter how long they've been with you. They're going to get the paid sick leave portion. So I want to spend a bit of time here on, so who qualifies, what employee becomes eligible. So they're going to be eligible under this paid sick leave part of the Act to the extent that they are unable to work or telework again due to a need for leave because of the following. The employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. I'm going to pause here for a second, and this is probably the biggest part of the bill people have the most questions on is, are we under a state or local quarantine or isolation order right now? And the answer to that is no, we are not. Governor Wolf has not used that terminology in anything. Right now we're at a stay-at-home order, and we are under order for non-essential businesses to close. So if you've had to close your business and lay people off, you're not covered under, they're not covered under the leave part of this bill. And again, you're not going to be eligible for the credit on paid leave. So just a quick clarification that I can try and offer here is quarantine orders and isolation orders are at this point typically more towards individuals rather than people groups as a whole or businesses. When California went under a similar order, several articles were published that quarantine is when you're exposed to the virus and you have to go self-quarantine for 14 days. Isolation is when you have the virus and you need to self-isolate, and but those mandates could come from a government agency. So I'd like to be as clear as I can that right now we're not under an isolation or quarantine order. So, and we'll I'm sure we'll have questions about that in the chat when we pause here. So, if the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So again, the first one's talking about a government order. The second one here is talking about ordered by a healthcare provider. If the employee is experiencing symptoms of COVID-19 and seeking medical diagnosis. So the first three here relate to what we're going to call and refer to as self-care. If an employee is seeking self-care, they're going to be under the paid sick leave portion of this act. And the reason we're breaking it into sections here is these first three, when it's self-care, are going to be subject to higher dollar limits that we'll get into here shortly. The second part, if an employee is caring for an individual who is subject to an order as described above, so if an employee is caring for anybody who's been sick or ordered to self-quarantine, they would be covered under this act as well. If the employee is caring for a son or daughter, if the school or place of care of the son or daughter has been closed or the child care provider of such son or daughter is unavailable. So, referring back to the FMLA part, if they say the first 2 weeks are unpaid, Well, now you have 2 weeks under here. And unfortunately, the bill is not real clear at this time. Does that make it then 14 total weeks? Do they get these 2 weeks and then 2 weeks of unpaid followed by 12? We're still trying to glean some information on that. So, but just be aware that the child care issue is going to apply here as well. So, and finally, the employee is experiencing any other substantially similar conditions as defined by one of these secretaries, and that's just basically saying if there's a similar illness in place there. Okay, so employers are required to provide 80 hours of sick leave to full-time employees, as well as provide part-time employees with sick leave equal to the number of hours averaged over a 2-week period of normal employment. So if you have part-time employees, and when I say normal employment, I mean that as kind of what they were working before coronavirus became about, because I have to imagine that many part-time employees have already started to scale back hours. So if they're still working and they become ill or need to seek childcare, it would be what they were normally working. So if they were working 20 hours one week and then 30 hours the next week, you would add those two together, divide by 2, and you'd pay them an average of 25 hours. So, and a couple clarifications on this that hopefully won't be too difficult of a pill to swallow here, but the sick leave must be provided in addition to the sick leave the employer already provides. So if you already, as a small business, provide sick time, whether it's 3 days a year, a week, anything like that, this is going to have to be offered in addition to it should somebody meet one of the conditions we just discussed. And you must pay out from date of enactment on April 2nd. It's not retroactive. So it is, if you're going to continue, if you're already paying or continuing to pay during this time, you're going to qualify. The 2 weeks are going to kick in as of April 2nd, and that's what the credit would qualify for. So, and if you have somebody healthy working now that comes down with the illness, while they're still working, you cannot force them to use your sick leave first. You have to give them these 2 weeks, and then pay them out any additional sick leave. The sick leave must be paid at the employee's regular rate to quarantine or seek a diagnosis or preventive care for coronavirus, or paid at 2/3 the employee's regular rate to care for a family member for such reasons, or to care for a child whose school or place of care has been closed due to the coronavirus. I'm going to refer back quickly 2 slides here. That's the back to V6. So again, self-care, talking about self-care here. These first 3 are going to be at full rates, okay? The last 3 are going to be at the 2/3 rates, and we're going to go over them here shortly. So if it's self-care, full rates. So the bill includes a maximum amount of paid leave of $511 per day, $5,110 in aggregate, so 10 working days times $511 per day, of full pay for sick leave associated with one's own diagnosis or preventive care. So if they make more than $511 per day, you don't have to pay the leave beyond that. If you do pay the leave beyond that, you're not going to be eligible for any credit on that monies above that. And you're back to the $200, same thing with FMLA, you're back to the $200 per day, $2,000 in aggregate for care of a family member, child, or other designated illness. So you'd be 2/3 pay, maximum $200 per day there. So just like under FMLA, you're paying the same amount for childcare. And I kind of briefly mentioned this, you can choose to pay above these limits, but you're not going to qualify for the credit in excess of these limits. Paid sick leave, if an employer, so two final notes here, if an employer is closing due to the state government mandates for non-life sustaining businesses to close, they are not going to qualify for the credit should they choose to still pay out the leave. So that is our interpretation. It's back to the first point about we're not under an isolation or quarantine order. So if you're just choosing to close your doors and you want to pay the leave, you can do so, but you're not going to qualify for any tax credits or reimbursements. If an employee qualifies for these leave payments, but the business is forced to close because of further mandates or lack of work, they can cease making leave payments and the employee can go on unemployment. This was we've had a number of clients with this question of what if I'm still open for business now, but I have to close the doors, and how we're reading this, how FMLA is certainly interpreting it, the original provisions of FMLA say you're allowed to be laid off in that time. You can't lay people off because they're taking advantage of this leave pay. But if your business needs to close for other reasons because you're running out of work, financial reasons, further mandates, then you can cease making those leave payments and the employees can go on unemployment. Just bear with me. I do see we have a decent amount of questions coming in here. I'll be stopping shortly again to address as many of these as I can. So the tax credits, what does it look like? So the Act provides a refundable payroll tax credit for employers providing paid family leave or paid sick leave wages under the Act due to COVID-19. And the refundable payroll tax credit is allowed for 100% of wages paid under FMLA and 100% of wages paid under sick leave. So either part of the Act that you're subject to and paying wages to, you're going to be covered and you're going to get a tax credit in full for what you pay out on this. So, and we'll get into how to claim that in a minute here. Eligible employers are entitled to an additional tax credit to be determined based on cost to maintain health insurance coverage for the eligible employee during this leave period. So if you need to continue paying the health insurance, there's going to be a credit for that as well. There's no guidance at this time on is that in addition to those wage limits, is it the full amount? So we do need to wait for some guidance there, but there should be some coming down on continuing to pay the health insurance. And you may still be able to deduct current withholdings for health insurance from these leave payments. Again, no official guidance there, but we are anticipating that it would potentially work like other leave, sick leave you already offer, vacation leave, where if an employee takes it and they're paying a portion of their health insurance, that you could continue to withhold that from them. Okay. Claiming the credits. How do you get the money back? The amounts paid as sick or family leave are not subject to the employer portion of Social Security and Medicare, but those taxes should still be withheld from the employee, okay? So part of this you're getting back right off the bat because you're not going to be subject to paying the Social Security and Medicare employer tax portion. Under the guidance released, eligible employers who pay qualifying sick or child care leave will be able to retain an amount of payroll taxes equal to the amount of qualifying leave they paid in lieu of depositing those taxes with the IRS. And if you can just bear with me a second, I'm going to have a couple examples here that I think will paint a pretty good picture of how this is going to work. The payroll taxes available for retention include federal income tax and both the employer and employee share of Social Security and Medicare taxes for all employees that were paid in the pay period. And if those payroll taxes are not sufficient to cover the cost of qualified paid leave, employers will be able to request accelerated payment from the IRS, and the IRS plans to expedite those refunds within 2 weeks of the request. So let me move to two examples here that I think are a pretty good picture. If an eligible employer during a pay period paid $5,000 in sick leave and is otherwise required to deposit $8,000 in payroll taxes, including the taxes withheld from all its employees, the employer could use up to $5,000 of the $8,000 of taxes it was going to deposit for making the qualified leave payments. And the employer would only be required under the law to deposit the remaining $3,000 on its next regular deposit date. So it's still going to follow your normal 9/41 deposit dates. And to be clear, that $5,000, that's not just the taxes that you're withholding on the leave. That's basically the gross wages. That's the gross leave wages that you're paying. You're just using taxes withheld to offset it. In the second example, if you're an employer and you've paid $10,000 in sick leave and you were only required to deposit $8,000, you would use the entire $8,000. You would not make that 9/41 deposit, and you would be able to request an accelerated payment of the additional $2,000. So that's how it's going to work. Again, it's not enacted till April 2nd, so you got to start thinking second quarter payroll here. I think that was somewhat intentional on their part because there's going to probably be a change to the 941 form, and we are rapidly approaching the end of the first quarter here, and the IRS was probably not going to be ready with those changes for the first quarter. And I'll also pause and mention here that that there's a bill in Congress, still in Congress, a stimulus bill in Congress right now that as of last night, I don't think had passed, and I apologize. I did not hop on and check before this call this morning, but that would potentially provide some further payroll tax relief. There's no guidance at this time on how these two will sync up, but you're going to get the credit back by basically deferring, either shorting your 941 payments or deferring them altogether and then shorting them. So just a quick note about self-employed individuals. The self-employed individual here, you're going to get an equivalent child care leave or sick leave credit amounts, and they're available under similar circumstances. These credits are, rather than through payroll tax credits, are going to be claimed on your individual income tax return and will potentially reduce your liability there and certainly potentially reduce your estimated payments that you need to make. They're subject to the same dollar threshold limits, so the $511 and the $200 per day, depending on whether it's self-care or family member care. And you would use average daily self-employment income to figure the credit. There's no, I hate to keep saying this, but there's no guidance on that calculation at this time, how you calculate the daily self-employment income. So you might need to wait for more guidance there. But if you are self-employed and run into these same issues, you potentially have you'll potentially be able to be reimbursed for credits there. Small business exemption. Small businesses with fewer than 50 employees will potentially be able to claim an exemption from the leave requirements, but it's only for the leave requirements related to the school closings or childcare unavailability where the requirements would jeopardize the ability of the business to continue. So you're not exempt when the employee meets one of the requirements noted where they themselves are sick or they're caring for someone who's sick. And I think that's in there mainly because hopefully we're really at the point where more people aren't getting the virus than have child care issues, but that we expect that the child care issues would be more prevalent. So you'd have more people that would potentially be subject to having to pay this leave. And it's also, even though the cap is lower, it's also for 12 weeks. So you have a better chance of jeopardizing your business there under that. So the exemption will be available on the basis of simple and clear criteria that paying such leave would jeopardize the viability of the business. And we are going to need to wait for the Department of Labor to provide emergency guidance on that to articulate this, because that in itself says simple and clear, but it's not simple and clear. We don't know. Does it just mean you can say you can't afford it? Is there going to be any additional burden of proof there at this time? There is also some guidance for healthcare professionals. The Secretary of Labor shall have the authority to issue, and I apologize, this isn't in the slides here, but the Secretary of Labor shall have the authority to issue regulations for good cause, and they are to exclude certain healthcare providers and emergency responders from the definition of an employee under this act, and the employer would be allowed to opt out if they're in the healthcare or emergency responders part. So that seems to be not subject to the 50 employee limit. Not quite clear on if that includes the sick pay when talking about self-care or caring for someone. But I think if you're between 50 and 500 employees, you might be able to claim an exemption if you're in the healthcare industry or on emergency responders. And just a few final additional notes about this act, and then we'll definitely hop to some questions here. Employees whom you've already laid off and are currently collecting unemployment would not be eligible for this paid leave, as they're no longer your employees. So kind of back to that first part, if where we talked about shutting down due to the mandates for non-life sustaining business, if your employees are already laid off, they're not eligible. If they become sick while they're laid off, they're not your employees any longer. So they're not eligible for this leave. You're not eligible for the credit. So I should note, like I said, PA has not. This is a federal mandate. Families First Coronavirus Response Act is a federal mandate that passed first, and then Governor Wolf came out with his mandates. We've actually talked to some state senators and things like that, and done as much research as we could to see if PA has issued any of their own guidance of how to interpret the federal law, and they haven't done so yet. But they could issue their own guidance. Just be aware of that. I don't know what that would look like at this time. Important to remember, if you are remaining open because you are a life-sustaining business or because your workers are able to work from home, you are under this federal bill should an employee become ill or need to start caring for a family member or child. So should have maybe mentioned that at the beginning, that obviously, again, if you've already laid off and had to shut down, you're not under this bill. It's not in effect till April 2nd. So you're not under it. But if you're going to remain open, or you're going to, for instance, our accounting firm is remaining open and we're working remotely, heaven forbid, if I become sick, I would potentially be eligible for this leave, and my employer would be eligible for the tax credit. This is an important one too. I think to note, I think I might have mentioned this already, but if a worker has already demonstrated that they can work from home while caring for their child, they're not subject to be covered under the paid leave part or the FMLA part, and you're not eligible for the tax credit. So just to reiterate that there. There is an employer requirement to post notice of these leave options within 7 days of the enactment. So that's going to be coming by April 2nd. So you're going to have to notify the employees, and the Department of Labor has issued some guidance there that they're going to be giving you something you can post. So, and we'll try to get that up on our website as well once it becomes official. And employees do need to notify their employers that they intend to plan to exercise this leave. They can't just simply stop coming to work. They need to give you a heads up that they're planning to take leave. Which brings me to the last point I want to make, that it's more imperative than ever at this time that when you are submitting payroll to your payroll preparers, that you indicate who is taking the leave so they can appropriately track and indicate whether it's FMLA or indicate whether it's sick leave and which category they fall into there. So please be notifying your payroll providers there. So an exhaustive overview, I feel, of the Coronavirus Act. I'm going to pause here, and I'll let Tracy begin sifting through some of these questions that I maybe haven't answered already.
Okay, we got a lot of good questions on here. I think some of them were already answered in your presentation, but it probably doesn't hurt to give a reinforcement of some of the questions.
Okay.
First question, is it true that the government will be covering 2 weeks of pay as tax credits for employees that are forced to be temporarily laid off due to the mandate?
I'll refer back to the point that under this bill, I would say no, that because they're forced to be laid off because the mandates are at a state level. There is the stimulus package that's in Congress now is probably going to have some coverage for individuals covering that, but it's not as it's stated in this bill. Would they be covering the 2 weeks through payroll credits if just because they're laid off?
And then just to reinforce, there's no need to pay for periods of March 15th through April 2nd.
Correct.
And then about the waivers for very small employers.
The waiver referring to the 50 employee exemption?
The 50 or the 25.
Yeah, if they're under those limits, the 50. The 25 piece, I got to be honest, is a little hard for me to define. And Tracy, if you do have any insight, I'll take it there on the 20. That's strictly talking about bringing them back to their job position. The 50-person exemption, like I said, there's not a lot of guidance right now on how do you say you can't afford it, like how, because you're looking at it from a standpoint of we're going to be reimbursed by the government. So how can we say we can't afford it? So I do think you're going to have, it's not necessarily going to be real easy. And I think it will look something like you have an overwhelming number of employees who need the paid childcare leave, and your business has already slowed down. It's already not bringing in revenue right now because other businesses are slowed down. The exemption there, we're going to have to wait and see a little on how that's exactly going to work.
Okay, the next question is regarding part-time employees. Does the FMLA and 80-hour sick leave apply to part-time employees?
Yes, it does. So there's no exemption, and that's back to the part where you have to take the average, the average of the 2 weeks work there.
Okay, we have a client who has 6 employees, including myself. We are shut down except for emergency calls. We are a fire and burglar alarm company. If my guys go to work and get sick, what happens?
Well, that's a great question. I would say under this act, because you are still on call, and that business, I believe, is considered a life-sustaining business. I don't want to contradict myself here, but you may have to pay out that leave. Tracy, do you have any thoughts on that? I don't mean to put you on the spot.
Yeah, I would think because you're not shut down completely, I would think that the provisions of the act do apply.
If you can follow up, I mean, I think the clear difference there might be, are those employees laid off? And it sounds like by that question, they're not. So if they're not laid off, you're still open, you'd be covered under that act, would be my interpretation of it.
I agree. Okay, next question. We had an employee file for unemployment on Friday when we heard we were shut down temporarily. However, we have full plans to bring him back. Does that disqualify him for these credits?
From the employer side, no, yes. I mean, you're not. So if he's filed for unemployment, if you have the employee file for unemployment, they're no longer your employee. So you don't have to pay the leave out, but you're not going to get the credit back, even though you intend to bring him back. You can't. If you choose to stay open, if that business happens to be a life-sustaining business, and you want to stay open now, before before laying them off, and pay those 2 weeks and get the credit. I believe you could do that. But again, you'd have to be in the life-sustaining business part. If you're already forced to close, then you need to lay them off as of Friday, and you'd not be eligible for these credits, and he would not be eligible for the leave.
A similar question here. Do I have to actually lay off all employees for them to avail of unemployment and avoid paying for sick leave?
I think that comes down to it's not an all or nothing. So kind of think back to my example where you might be a non-life sustaining business but have life sustaining jobs that you want to keep open. The employees it's kind of a little bit of discrimination here, I guess, but the employees that you lay off are no longer your employees, so they don't qualify. The ones that are staying on to complete these jobs, or to be clear, even if you're a life-sustaining business and you've had to lay people off just because of lack of work, anybody who's laid off because of lack of work is not covered under this provision, and they're not your employees. So it's the ones who are staying on and staying in the offices or working that would be having the credit.
Okay, under the Act, if an employee is able to telework, but not the same number of hours he or she would if the physical office was open, does the Act still come into effect, or does any amount of telework prevent the application of the 12-week FMLA pay requirements?
I would say, again, that employee's not laid off, so they would be covered under the Act, even if their hours were reduced. And if they were full-time before, and now they have to be part-time because they can't work as many hours, I would say you're still subject to the full-time rates if they get sick. You're not going to be able to do that part-time calculation.
Okay, do you have any idea how an employee applies for this? Is it just a phone call, or is there a form?
Well, when talking about applying for the leave, they just need to give you notice. Like once it's enacted, they're not applying for the leave. You are paying them to leave. So there's nothing they need to fill out or form. The bill doesn't go into burden of proof like you need a doctor's note. But I mean, there's a bunch of stuff in the bill that's about good faith effort. So if the employee's making a good faith effort to tell you that they're sick and they need to take the leave, and they're trying to further prevent the spread of the virus, I think that's enough. I think that's substantial, and then you would just simply pay the leave. So there's nothing they need to do to apply, and then there's really nothing, in my opinion, that you need to do to apply for the credits at the moment. They're probably going to issue guidance on, like I said, when they go to do those 941 forms at the end of the quarter, you're probably going to have to indicate there like what you took as a credit on the 941 deposit. But short of that, there's no Tracy, am I saying that right? There's no application process.
That's correct, yeah, unless they come out with something in the regulation. Just to reinforce the issue, if the employee is already laid off prior to April 2nd, then this doesn't apply, correct?
Correct, that is correct. If they're already laid off, it does not apply. Truly think of the layoff piece as, layoff does mean they are no longer your employee. So this act is for employees. If they're laid off, they're not an employee anymore.
Okay, if we currently have an employee that is on self-quarantine because his wife has shown symptoms, are we required to pay them the additional 80 hours at this time?
So that would be back to, if he is still on self-quarantine come April 2nd, he's going to get the 2 weeks. If you've already been paying him on current sick leave policies or out of the kindness of your own heart, they are going to, if he is still on quarantine come April 2nd, however long after that, up to 80 hours, you would still pay out that leave to him, and he would be, you would be eligible to be reimbursed in full, of course. So.
Okay, FMLA question here. We have under 50 employees and did not believe we needed to offer FMLA. Does this bill extend FMLA to all small businesses, no matter the size?
The FMLA part of this act did not. It's still so separate for a second the sick leave part and the FMLA part. Under the sick leave part, you're going to have you're going to have that burden of proof. So if they have the child care, I guess where I'm going with this is you might have to pay out 2 weeks under the child care portion. If FMLA, it's an expansion of FMLA, but it hasn't changed the original employee limits. So would I be saying that right, Tracy, that they, if they're under 50 employees, they would potentially be exempt there?
Yes.
Okay.
Only for the child care, though.
Only for the child care, correct?
Yeah. And another reinforcement here, what type of proof does an employee need to provide in order to receive emergency paid sick leave?
That, as mentioned, that's what's still up in the, well, maybe I haven't mentioned that, but that is somewhat up in the air on what they need to do to prove this. The burden of proof that they're taking it, I haven't seen on what requirements they are. Again, it's back to that good faith effort at the moment. I'm hoping additional guidance will be released on what the employer's burden of proof is to claim the credit.
Okay, the active paid sick leave benefits are not eligible until April 2nd, correct? I currently have an employee at home in self-quarantine due to a sick child awaiting COVID-19 test results. He's been out of work over a week currently.
Right, so unfortunately, if you're hoping to pay him sick leave and get reimbursed for the credit, it's not going to, as we're understanding it right now, it's not going to take effect till April 2nd. So there's been nothing issued on what happens if you decide to pay it now. So we're encouraging our client base. We're not sure. So if you want to pay it out now, you can. You might get the credit for it, but we're reading it as it's enacted April 2nd. So you're kind of at your own risk if you're going to pay out anything between now and April 2nd and hope to get the credit for it.
Okay, if we have employees who are collecting unemployment due to lack of work and we are continuing to pay health care coverage, do we qualify for a credit?
I'm going to defer that question for the moment. And I don't know that I'll have an exact answer on that, but we're going to talk a little bit about the health care, paying health care while out on unemployment under that act. But I will say for right now that part's not clear. That's back to the health insurance, covering the health insurance. There's going to potentially be some credit there, but I think that's in conjunction with the leave part of it, not necessarily paying it while people are on unemployment.
Okay, if an employee in a life-sustaining business has a baby and fears that going to work may expose him or her to the virus and possibly bring it home to the baby, are they entitled to paid leave? That's
an unfortunate situation, but fear is not covered under the bill. You have to be presenting signs. So if they are in a life-sustaining business, now if we're talking, they just had the baby, that's probably a whole nother FMLA issue that I'm not going to get into right now. But if they recently had a baby and they're back to work, but fearful that they could bring it home and they're in a life-sustaining business, they're unfortunately not going to get, you're not going to get credit for paying that leave. I'll say it that way.
Okay. How can a business say they can't afford it if they get all the money reimbursed from the government and none of the sick leave payments end up being paid by the business and not being 100% reimbursed?
I would say you can't say that then. It's truly, like I said, that exemption piece is going to be a tough thing, I think, to claim because of the fact that they're reimbursing it. So, it's really going to be, they haven't, again, offered guidance on how you prove it, but if you have 25 employees and they're all they're all have childcare issues at home and they need to stop working, and you can't continue your business, continue making money, that's where I think you'd have a case. But short of that, I do think that they're not looking for people. The bill's not intended for people to be claiming the exemption. I don't think it's trying to say, hey, you need to offer this and we're going to reimburse you for it.
Okay, regarding the small business exemption, is the 50 employee limit measured as of April 2nd, or is it still averaged over the 6 months?
I will have to get back to that person on that question. I do not know the answer to that. Do you know the answer to that?
I believe all of the employee counts are on the date of enactment.
Okay.
Yeah.
Yeah, I will say I did not see anything about average employee counts or anything like that. So I'd be safe to assume, I think it would be safe to assume that it's date of enactment, just like the 500 employer limit is in place.
Do you know what a PRN employee is?
PRN?
Yes.
I do not. I apologize.
Maybe we can get some clarification on that question. On claiming the credit, this was originally pitched as being revenue neutral to the employer, in that whatever is paid out, the employer will receive back in the form of a payroll tax credit. But in your examples, a tax credit is not the same as reimbursement, correct?
Correct. I mean, in those examples, well, it's refundable. That's what I hope I'm being clear here. When they talk about revenue neutral, you're going to claim it as a credit against taxes. But if you are in addition, if your leave is in addition to what you paid in taxes, then they would be issuing accelerated payments to try to get it to you quicker. So, do you have any additional thoughts on that, Tracy? I hope that clarifies that question.
Yeah, I mean, the bill is intended to be fully paid by the government, so that if you're paying the FMLA leave or sick pay leave, that you're reimbursed by the government up to those dollar amount limits.
Tracy, do we still have a number of questions to go through? Yep.
We still have a couple, yeah.
Okay. If we don't mind, because I did want to at least get through the material within an hour. I'm just going to move on to the PA unemployment piece quick and go through that. That won't take terribly long, and then we can go right back to answering questions. But that way, if there's people that need to hop off the call, they can at least hear the PA unemployment portion. So if you don't mind, we'll get back to your questions in a moment. So PA unemployment tax rate relief, I hope I can offer you some good news here. So, back to our point, as businesses are forced to stop working or temporarily close their doors, your employees are able to sign up for unemployment and begin collecting benefits. If you've laid your employees off already, it probably would be wise, if you haven't done so, to issue them a notice in writing that the layoff was related to COVID-19 and, and put a retroactive date as to when they were laid off. I think that'll help strengthen your case, hopefully it doesn't even come to this, but strengthen your case should you have to challenge an increase in PA unemployment tax, and we'll talk about that in a second. PA unemployment is recommending applications to be done online and has eliminated the waiting week and work search requirements, for recipients. So normally there's a week waiting period. Normally there's some things you have to do to show that you're looking for new employment. They're waiving all that right now, and that's obviously with the intention that they're only on unemployment due to COVID-19, and they'll begin going back to work as soon as they're able to. So This is prevalent throughout the PA's UC website. The employees are encouraged to work with their employers and first exhaust any paid leave available, as unemployment benefits are only going to cover somewhere between 50 and 70% of normal pay. So I am taking this fully to mean that they are telling you you need to pay out your sick leave, sick leave, vacation leave, and things you already offer before laying your employees off. And if you're in the midst of laying off and they're covered under this Sick Leave Bill Act, you'll want to pay that out unless you're forced to. Well, I don't want to contradict myself there. I did say that the leave part, if you need to lay off because work has stopped, you can do that and stop the leave payments, and that is true. So we'll keep that at that. If an employee can choose to work, if an employee can work from home, telework, and chooses not to, they're not eligible for unemployment benefits. So we're not talking about the Leave Act here anymore. We're talking about unemployment. If they can work from home, they're not going to be eligible to claim unemployment. And in addition, they cannot file for unemployment if they're staying home due to child care. They can file for the leave portion, but if you're staying open after the leave portion is paid, they unfortunately cannot file for unemployment. And I don't know at this time the semantics of just choosing to lay them off so they can collect unemployment and how that works. I'd recommend not going down that path. The biggest part of this, most important, businesses closed due to COVID-19 are going to be granted relief from charges, and your unemployment tax rate will not increase because of these claims. So your rate is assessed annually, and the employer portion can jump around pretty good depending on your history. And a lot of times as you're laying people off, that rate can be jacked pretty quickly, and they're not going to be doing that due to COVID-19. And I believe the way they're going to track that is when the employees apply for unemployment, they're going to say it's due to COVID-19, and when they go to reassess your rates, they're not going to be looking at those cases, at those claims. Now, there does appear to be eligibility for unemployment benefits if you're simply reducing hours. I unfortunately don't have exactly what that looks like. I'd recommend if you're reducing people's hours from what they normally work, there does appear to be some eligibility there, but you're really going to have them go through the application process and potentially talk to somebody at the unemployment benefits office. So, you guys as small business owners, unfortunately not eligible for unemployment benefits, and that does not seem to matter what type of entity you are, LLC, S Corp, C Corp. As a business owner, you're not eligible for unemployment benefits. I'm not going to go into the semantics of, well, why do you have to pay it in? Because I don't have a good answer for you there, other than to keep pouring stuff into your account so your rate doesn't go up. But just to be clear, you're not eligible. This is somewhat related to the question that was asked earlier. While employees are on unemployment, you may be able to continue offering health care coverage. I'm going to tell you right now that discussion needs to be had with your health care provider. We can't answer that for you. That's not a state mandate saying you can do it. They seem to be leaving that up to the insurance carriers at the moment, but we're hearing that some insurance carriers are going to continue to let you pay the health care while they're on unemployment. Normally it would go into COBRA, and they're not necessarily going to force you into COBRA. What that looks like as far as, if they're currently contributing a portion to their paycheck and now they're on unemployment, how do you get all that back? Again, you'll have to work that out with your healthcare provider of how that works. So there unfortunately is no part of the bill that addresses or discusses 401k loan repayment. So obviously with the shutdown and putting people on unemployment, again, I'm not hearing anything where you'd have to terminate 401k plans at this point or anything like that. I believe you could still maintain them, especially under the plan to bring people back. But specifically, if your employee has a 401k loan repayment, as it stands right now, if you go into unemployment or default on the loan payment, let me rephrase that. It's not necessarily just going into unemployment. It's simply if you default on the loan repayment, within 90 days, they'll term it out and it'll be a taxable event to you. So you need to have discussions with your employees about this. If they have a 401k loan and you're planning on putting them on unemployment, if they can continue to repay it through the unemployment check, and give you a check to deposit back to your 401k company, I believe that's still acceptable. But again, have that discussion with your plan provider there to see if there's any specifics. The last thing I want to mention here in the presentation, and then we'll go back to questions, disaster unemployment assistance. If you've heard about this, it's not available yet. And what that is it's for self-employed small business owners and a way to get some credit, back up to the point where I said, well, you're not eligible for unemployment benefits. You might be available for some disaster unemployment assistance. However, the state of Pennsylvania has not been declared a disaster yet. And there's a specific phone number that if this becomes available, we will post on our website. But the phone number I did call that right before hopping on this presentation, and that phone number is not even active right now because they specifically say Pennsylvania has not been declared a disaster state yet. So interpret that as you may. If you feel like we're a disaster, they haven't declared it yet. So that brings us to the end of the material I wanted to go over. We're going to hop back on with some question and answers now. But I appreciate all of you for listening.
Okay, Drew, question about unemployment here. If employees are collecting partial unemployment due to lack of work, are they covered under the leave?
I would say on that, if they're collecting partial unemployment, but they are still being paid. So if we're talking about that reduced hours, so it sounds like somebody might have already gone through that. They're still getting paid by you. So at that point, even though there's a provision where they're collecting partial unemployment, which I think you have to understand is usually not the case. You usually can't do that. You would be covered under the Leave Act. Would you agree with that, Tracy?
Yeah, that sounds like a reasonable assumption.
Yeah, I'd say I'd interpret it to mean that anytime I am still paying an employee out of my payroll, they are still my employee. If I'm not paying them out of my payroll, then they're not my employee.
Okay, if someone has filed for unemployment but do not receive approval for unemployment, are they still considered your employee if you have not formally removed them from payroll?
I would say yes, if you have not formally removed. If you've given them the layoff notice, I think you might be covered there then, that your intent is to lay them off. I unfortunately don't know all the formalities of how somebody would be rejected for unemployment. So I would say if you haven't taken the appropriate measures on your end to notify them of the layoff, then they would still be considered your employee. I think once you've given them the notification, I think that's part of the reason that notification is important. I think once you've given them that notification, and you can show that the rest of your workforce is laid off, then I think you'd be okay and they would not be subject to the leave.
What if you call them back from unemployment? When does their eligibility start?
I would say that's the date. If it's after April 2nd, then their eligibility starts that day. So there's no waiting period once they're off unemployment and back on your payroll. Everything we're talking about here, when we say that April 2nd, I should have mentioned this way up front, but April 2nd, think of that as time during your pay period. It's not paycheck date. So the day April 2nd starts, it's enacted, those working hours account. So if you have somebody on unemployment and you bring them back before then and they happen to get sick, then that's fine. But date of enactment is date of enactment. So if they happen to get sick on March 28th and go into act April 2nd, they're whatever days they're still on quarantine, they're covered up to 2 weeks or staying home. So even if it transitions into the April 2nd piece, you know, the April 2nd date of enactment, 2 weeks from that date. So even, and Tracy, before you move on, one thing I'd like to be clear of, a lot of people always hear, well, 14 days of quarantine, 14 days of isolation, you know, and you're factoring in the weekend there, so that's 10 working days. This act is as long as people are out. So if you know, it's up to 2 weeks. So if they for instance, back in my March 28th example, if they transition to having the disease, the virus into April 2nd, and they're out April 2nd through April 16th, 14 days, you're paying them those 10 working days there. So.
Okay.
I'm sorry. One last thing I'd like to point out. Just remember too, the limits in the leave we're talking about, they're 10 working days. Okay, so don't pay out 14 days. Don't include weekends.
Okay, what if we have not laid off the employee, but they are choosing to stay home because of the governor's mandate? Are we still required to pay them the sick leave, child leave?
No. Again, back to fear. Unfortunately, fear or concern, or I mean, you could obviously say it's not fear, it's just best practice. But if you are currently open and they're choosing to stay home, you're not required to pay them the leave. Oh, please don't ask me how that contradicts with the ethical standards of trying to combat this virus, because I don't know.
Okay, I'm unclear. Are the reimbursements only for life-sustaining businesses whose employees can't work? Or is this also for non-life-sustaining businesses who have been mandated to shut down by the state?
If they've shut down, so if they've shut down by the state and you're not putting them on payroll, I mean, so to be clear, I don't think there should be many scenarios where you're shut down and not asking your people to go on unemployment. Would you agree with that statement, Tracy?
Yes.
Okay. So keeping that in mind, they should be on unemployment and then not covered. You know, if you're shutting down and they're not on unemployment, then they're still your employees. And again, not because they've been rejected. I mean, if you've taken action to notify them of layoff, then I would consider them not their employees if they're rejected from unemployment. But if they just are not, I mean, that's where I would encourage them to file for unemployment, because your rate's not going to be jacked because of it. You know, if you're telling them not to file for unemployment, then they're still your employees, even if you're not paying them, and then therefore they would be covered under this act.
Okay, this is a good question. When will the reimbursement come to the business owner? What's the turnaround time?
So again, the reimbursement piece would be the part where you're paying in excess of your 941 liability, and the IRS plans to expedite those. You have to request an accelerated payment, and I apologize, there's no guidance on exactly right now what the request looks like, but I'm certain that piece will be coming. But once you request that, the IRS is planning to turn around the refundable part in 2 weeks. The rest you're being reimbursed by short paying your 941 liabilities.
Okay, if you have a small business, which is a corporation, and the only two people in the business are the husband and wife, and you can't make sales calls and residuals will drop because the businesses you service have minimal business, will there be any reimbursement from the government other than loans?
Ooh, that's a good question. That, to me, would possibly come back under the disaster unemployment assistance if that's issued. If they declare the state a disaster. The stimulus package, again, I'd rather not get into too much of it right now because it hasn't been issued yet as far as I know, and I haven't had a chance to read through all the stuff. But the stimulus package is also talking about some reimbursements and payments out to individuals as well. So there might be some assistance there, but your SBA loan, unfortunately, is probably going to be your best case scenario for keeping the business afloat if you're just a husband and wife. Now, if your wife is not an owner of the business, or spouse, I won't say wife, spouse, if your spouse is not an owner of the business and you're paying them on payroll, they could still be laid off and collect unemployment. So that business owner's piece doesn't apply to family members that are paid for the business. So you have to have some work history there. So don't just try to throw your spouse on payroll or family member on payroll now and try to get unemployment benefits. I think they'll see through that pretty quickly.
And that was actually our next question. Are your family members who work for you able to collect unemployment benefits, specifically wife and children?
Yeah, so yes. I mean, the unemployment restrictions that I was saying are just on business owners, not on family members. So they don't own a part of the business.
Okay. Any idea why they decided to use an April 2nd, since that's a Thursday? If you have a 2-week payroll, and it's split between pre-April 2nd and post-April 2nd, and also split between work time and FMLA leave, how are you supposed to account for all that?
All right, let me try to address this in stages here. Do not know why they specifically picked April 2nd, being that it's a Thursday. I believe they picked April 2nd just because, and I don't know why it wasn't exactly April 1st, but I think they were trying to give themselves 15 days from the date of enactment. And more specifically, I think they were trying to push it into the second quarter. I think they wanted to start as soon as they possibly could into the second quarter to get these benefits paid out. So, but they were going to need time to adjust the 941 liability. So it's from date of enactment. So again, it's just important, if you can, to communicate with your payroll company. And I know our payroll companies, if you use our in-house payroll services, we're going to be doing the best we can to be in communication with you about this. But your payroll provider, notify them of the hours. So if you have a split payroll period and everybody was either taking reduced hours or not really being paid, but all of a sudden April 2nd hits and they're out on this child care leave, or they're out on this medical leave, then you would just indicate those hours separately. I know our payroll companies are going to be utilizing specific payroll items for this. So they're going to be setting up specific payroll items to keep track of the hours and keep track of the fact that it's not going to be subject to Social Security and Medicare. That's one other reason I'll throw in the April 2nd piece. They also did need to give payroll companies and software companies time to comply with this, because they're going to have to make some adjustments in their system, as usually this type of stuff is not taxable. So.
Okay. If you're an LLC taxed as a C corporation, then the owners would qualify for leave and the business would qualify for the credit, right?
Yes, I believe so, because you're on payroll at that point. Yeah, I want to be distinct between talking about unemployment and the leave. So, if you yourself as a business owner get heaven forbid you get sick or things of that nature, you're paying yourself, you would be eligible for this sick leave as well. So yes, I believe that is the case. And you'd be eligible for the reimbursement.
Okay. How about minority business owners eligible for unemployment?
2% or less might be able to. I might have to get back to them on that, unless you know that answer, Tracy.
Yeah, I'm not sure.
Okay. Yeah, we'll
only if you're a corporation, I think it's only the office that you have to worry about.
The officers?
Yes.
Okay. Yeah, we'll do some research and get back, confirm that.
Okay, I am a small private school. My teachers are giving education on Google Classroom. However, I plan to put some of the teachers on unemployment because my accountant's advice is to cut my payroll in half. So my question is, some of these people can work from home, but I can't afford to pay them all because my payment comes from other school districts, which are also closed.
So is the question there, can they lay people off?
I think they just need financial assistance of some kind.
Oh, the ones they're keeping on pay. Okay.
Yeah.
Yeah, the ones they're keeping on pay, that might be the SBA loan route. And I will say we're Governor Wolf has enacted that piece of it. We're not covering that in this webinar, but I will give you a heads up. There's going to be a email blast in the coming hours here, hopefully today, that talk about how you go about applying for the SBA loan and what that process looks like. But the first step was the governor had to request assistance from the SBA, and he has done that already. So I'd lean you towards that. If your businesses or school districts are shutting down and they're not paying, outside the SBA loan right now, I don't know that there's much other relief short of what comes out in this stimulus bill.
Okay, little unclear on this question. I'm an S Corp and paid by W-2. What can I do? I think this goes back to the unemployment question.
Yeah, and again, as officers, owners, I get it. I get as an S Corp, you're paying yourself, but you're unfortunately not eligible for unemployment. So you're gonna, if your business can't. So I want to be clear: if you're shutting down your business because of the governor mandate, but you as the owner of the business are still continuing your day-to-day functions, even if you're not, as a business owner, you can still take payroll. So your payroll can consist now of only you or other owners while the rest of your employees are laid off. Obviously, you need the money to do that. You need to be able to pay yourself. So again, I hate to keep referring back to it, but refer you back to you're going to have to probably apply for a small business loan. Or talk to your bank. We're always saying small business loan. Banks are trying to be as flexible as they can be too in this time, from what I'm hearing. So talk to your lenders at banks and see, if you're running low on cash, see about extensions of line of credit and things of that nature. But again, you're probably going to be subject to whatever the SBA offers and whatever stimulus comes out in the bill coming out soon.
Okay, that was the last of our questions.
Okay. Well, if you don't mind, we'll call it there. I want to thank you for your time today, and I hope this offered some clarity into what your responsibilities are as an employer in the coming weeks. As mentioned at the beginning, we're going to be sending out a recording of this webinar. We're also going to attach these slides. And if there's any helpful website links or phone numbers, we'll also try to include those as well. My contact information will also be included. If you have any other questions you did not think of or still need guidance on, please do not hesitate to email me, and I will do my best to respond to you as quickly as I can. Again, the recording is also going to be posted to our website. And speaking of our website, that is where we will be posting updates if there are changes or new developments on anything we discussed today. So please be checking back there frequently. So on behalf of the entire firm, I want to sincerely thank you for the opportunity to serve as your accountants and trusted business advisors. And please stay safe out there. Thank you.